Let's now look at the legal position where a seller provides a warranty, but the warranty turns out not to be accurate. What can the innocent party, usually called the non-breaching party, do about it? The situation under English law is that a court will first of all ask the non-breaching party to state exactly what's been lost as a result of the breach of warranty. If there's been no loss at all, then the non-breaching party probably doesn't have a case. There usually has to be some kind of definite loss before a court will get involved. So, let's look at a situation where there is a definite loss as a result of a breach. Think about this scenario. David agrees to buy a used marquee tent from a company. David has a business renting out marquees for weddings and other celebrations. The cost of the marquee is £6,000, which David doesn't have. So he agrees to pay the company in 6 equal monthly installments of £1,000 a month. In their written contract, the company warrants that the marquee is completely waterproof, meaning that, even in very rainy weather, people inside the marquee won't get wet. In fact, this isn't the case. David then rents out the marquee for a wedding, and unfortunately, it's a rainy day. Some of the guests get soaking wet, and the furious renters refuse to pay David the full price for use of the marquee. So, as a result of the company's breach of warranty, David claims that he's lost £2,000. If the company which sold the marquee to David refuses to settle this with him, David might sue them. He'll ask the court for what lawyers call a remedy for the breach of warranty. Remedy is the correct legal term for a solution to a contractual problem. What will the court do? Well, the court will look at David's loss and try to work out a sum of money that would put him in the position that he would have been in if the warranty had been accurate. If David's claim is successful, the court will award him damages. Damages means financial compensation for a loss. David may get the full £2,000 he's claiming, and he may not. It depends on the circumstances. But here's the bad news for David. Damages are probably the only remedy available to him, and the court is very unlikely to allow him the remedy of terminating the contract. Why not? Because a warranty is seen as a secondary provision of a contract. This means that as a statement of fact, it's not seen as being as important as an obligation, which is something that the parties shall or will or must do. So, because a warranty is seen as less significant than an obligation, the breach of a warranty won't usually give the non-breaching party the right to terminate the agreement. It's just not considered a serious enough breach to allow that to happen. If David expects to be able to walk away from this contract, he'll probably be disappointed.